Well, we're back sooner than expected to share some news that we heard late last week. He's Andrew, I'm Nate, and this is a bite from the DLC's Policy Corner.
"27 years ago this Sunday, the Supreme Court decided Olmstead versus LC. Two Georgia women, Lois Curtis and Elaine Wilson, had been held in a state hospital long after their own doctors said they could live at home. The court ruled that locking people away when they could be safely supported in the community is discrimination under the Americans with Disabilities Act. That decision, paired with Section 504 of the Rehabilitation Act, became the foundation for home and community-based services across the country, including the waiver programs that today serve thousands of Utahns with disabilities.
4 days before Olmstead's anniversary, the Department of Justice Office of Legal Counsel issued a memo arguing that the ADA and Section 504 don't require states to serve people in the most integrated setting, and that federal regulations enforcing that integration mandate go too far.
Let's be clear about what the memo does and does not do. It does not overturn Olmstead. It does not repeal the ADA or Section 504. It does not rescind the regulations. That takes formal rulemaking. It does not bind a single federal court. It does not affect those receiving or waiting for services, and it does not stop you from enforcing your rights in court.
What it does do is signal the federal government may stop being the watchdog. It hands the states a script for slowing community services, citing cost or capacity, and it lands at the same moment the president is asking Congress to cut our protection and advocacy grant for mental illness by 65% and eliminate 3 other protection and advocacy programs, encouraging institutionalizing homeless people, calling HCBS fraud, and adding a harsh work requirement to Medicaid that will lead to many losing coverage.
Across the country, disability organizations are speaking with the same voice. Olmstead is still the law. In fact, Utah State University's Institute for Disability Research Policy and Practice issued a brief urging strategic litigation, state-level codification of the integration mandate, and full HCBS funding.
We'll keep talking to elected leaders and policymakers, watching for new rules, monitoring institutional admissions, and enforcing your right to live in your home and your community. Because the promise of Olmstead isn't just a doctrine, it's our families, our friends, our neighbors, our jobs, our lives. And we will keep you updated if anything changes moving forward.
We know this is a tougher bite to swallow than usual. As always, we'll do our best to make sure you know what's going down and what's coming up. Until next time, thanks for watching.